Good afternoon, everyone, and welcome to today's edition of The Law and You. I'm your host, yours truly, Shellon Washington, attorney at law licensed in the state of New York, in the country of Guyana and Trinidad. Today, we will be bringing you a special edition regarding landlord and tenant issues affecting landlord and tenants in the state of New York. More particularly in the city, in the five boroughs, because the things that we're going to be discussing are more applicable to those people who reside within the five boroughs of New York City. Today, joining me will be my colleague, James Williamson, and we will be discussing this. I will be discussing from the landlord perspective, and my colleague, he will be discussing this from the tenant's perspective. There are several issues which affects your rights as both a landlord and a tenant. I only strictly our office represents landlord, and my colleague, like I said, who's joining me today, he represents the tenant side. I think my colleague is here, so the operator is going to let him in, and he'll be joining us. Hi, James. How are you?
Mrs. Washington, how's everything going today? I'm doing okay. Nice Saturday, nice weather outside, and I hope everybody else listening is doing all right as well. Definitely.
Great. It's nice to have you here today. And today we're going to be breaking it down for people living in rental properties in
Okay.
the state of New York. Today I'm going to start off with the landlord side, because the landlord side, I think, that's the side I'm more familiar with. I've represented people on both sides, but now I only represent landlords, because I realize most of the landlords from underprivileged communities, those from our countries, from the islands, the Caribbean, and places that I'm more familiar with, there's a lot of things going on in the court system that I don't know if the state is designing this. So I think they're protecting the tenants, but in protecting the tenants, they're crushing the landlords. I'm going to get into some of the stuff. The first thing is in 2019, there was a change in the laws as it relates to eviction. Prior to 2019, an eviction was done by a 30 days notice. The landlord was permitted to serve a 30 days notice, and within 30 days, if the tenant failed to remove themselves from the property, then the landlord would proceed. And I'm speaking about a holdover. I'm not speaking about a non-payment. That's where we're going to start. We're starting from a holdover proceedings. And a holdover proceedings in the state of New York occurs where a tenant and a landlord has a relationship in a property that is most likely, but not necessarily the only situation, but the property is most likely not rent regulated. It's a non-rent regulated property, and the landlord would like to get the tenant out, either because the tenant is not paying the rent, or maybe it's just a bad tenant that is destroying the landlord's property, and the landlord would like to get that person out. In that case, with the holdover, the landlord was permitted before 2019 to serve a 30 days, get the tenant out. After 2019, new laws went into the effect. Those laws states that you can only serve a tenant a 30 days notice if the tenant has been in your property for 1 year or less. It has to be under a year. Once you get to a year and over, you have to serve that tenant a 60 days notice. And then once it gets to 2 years and over, the law mandates that the landlord must serve a 90 days notice. So the landlord has to sit there for 90 full days before he can initiate any eviction proceedings against that tenant. The other problem with the court system right now, is that after you waited that entire 90 days, if the tenant has been there 2 years or over, and then you move to the second aspect of the proceedings, which is to file eviction proceedings in the landlord and tenant court, which is the civil court in the case of Kings County. It's on Livingston Street. You move to that stage there, and they take almost 2 months to assign you a petition number and a court date. And now they're assigning court dates up to 6 months out. So the system is really lagging, and it's very difficult for the landlord on the landlord perspective. And I'm not sure if they're trying to run people out of New York. I'm not sure what New York is doing there. But the bottom line is the small landlords are suffering because it's difficult for them to keep up with the mortgage if the tenants aren't paying the rent. And then they have to wait for months to even get to the court. And when they get to the court, the other side of this is the trial. Now, this is from the landlord perspective. Now, I'm going to ask my colleague, Mr. Williamson, what are some of the reasons do you know that a landlord would evict a non-regulated tenant for?
Well, I mean, there's numerous reasons. The most common that I see is going to be, they stay past their lease. Perhaps the landlord might have the opportunity to rent that house out or to rent that apartment out for a little bit more money. Who knows? Maybe the tenant was a nuisance when they were staying there before. You're allowed to evict on those grounds, but the whole thing is they're past their rent regulated lease. And,
Ms. Williamson, just one thing. This is for the non-regulated tenants. We're dealing with the non-regulated ones, and then we'll move to the regulated tenants.
Gotcha. Okay. All right. Well, I mean, the most common reason you're going to see is that the tenant is past their lease, and that's pretty much the only reason in a holdover that a landlord is going to need to evict the tenant.
Right.
They stay past the expiration of their lease, and that's for a non-regulated tenant.
Right. Or it might be a case where the tenant is just not paying the rent also, because sometimes I know tenants get into situations where they fall back on the rent, or they're paying the rent late, or they just can't meet the rent date. And that's something that really affects the landlord. And I don't think a lot of tenants see it from the landlord's perspective, that the landlord is just trying to get paid so he can take care of the expenses on the property, which might include mortgage, taxes, water, utilities, whatever other utilities he might have to pay, maybe the gas. So I think a landlord would be expecting his rent. The second one is the rent regulated tenants. From the landlord perspective, the rent regulated tenant are people who are living in a unit with 5 or more. You're living in a building with 5 or more units, and that unit, that building is going to be considered fall under the rent regulation law. It's either going to be rent control or rent stabilized, depending on what year that property was built. And or if you were registered with the rent control board, then the property would definitely fall under rent control versus rent stabilization laws. So it just depends on which part of the spectrum the landlord falls. In that case, the eviction process is a little bit different. It doesn't require those notices that I told you about, except if that tenant need to be evicted for some sort of illegal activity. There are grounds like if the landlord wants to take back the property because a family member wants to live in there, he can evict that tenant on a holdover. Or if the landlord wants to we already said if he wants to put a family member, or if the tenant is committing some nuisance or illegal activity on the property or damaging the property, those are all basis for the landlord to evict that tenant on a holdover proceeding. Now, I'm going to turn to you now, Mr. Williamson, as it relates to outside of those areas that I've already mentioned. What are some of the most common ways a rent-regulated tenant could be evicted for?
Some of the ways that they can be evicted?
Yes. What are some of the reasons a landlord would choose to evict a rent-regulated tenant?
I mean, well, I think you mentioned most of the major ones. You have they're not paying their rent. You don't have to collect rent. You can, in that case, evict them because, they're past their lease. You can use that as a pretext to do so. And then you can come back after them in a plenary action in Supreme Court. But non-payment of rent, other than seeking the option of doing a non-payment case, which I'm sure we'll talk about, that's a major reason. You already mentioned nuisance. I think I mentioned that in the beginning. They're creating a hazard. As a matter of fact, one of the very first landlord-tenant cases that I was on was a holdover proceeding where the people were running a motorcycle repair business in the back of the house. You know, they were loud, keeping neighbors up all night. They got into a back and forth with the landlord, and that was one of the very first reasons I encountered as to why a landlord would not want to renew a lease and want to evict somebody on the basis of a holdover. So nuisance is a major one that you're going to see. The landlord and tenant being at odds. Uh,
Right. And I think a lot of tenants miss the one of the reasons also is refusal to sign a lease renewal, because a lot of tenants in rent control apartments, sometimes the landlord would send the lease and ask them to sign the lease renewal, and a lot of them refuse. I'm not sure why, because you're mandated by law to sign that lease renewal. If you refuse to sign it, then the next thing the landlord is going to do is serve you notice that he intend to evict you for your refusal to sign that lease renewal. It's very challenging right now for landlords. I think the law is more skewed in favor of the tenant. But when the landlord has that type of opportunity to
right.
sue or send a notice to the tenant and tell the tenant, I will be evicting you for refusal to sign the lease renewal, I think that's really important because, and I think a lot of the smaller landlords, this affect mostly because they don't have a rental agency that is managing the rental properties for them, that knows when the lease renew, that they need to recalculate the rent at the increased amount either every year or every 2 years and send the appropriate lease renewal. And if the tenant refuses to sign the lease renewal, it prejudices the landlord's right, because when they refuse now, whenever that form is signed, the landlord is going to lose rent. He's going to lose his ability to increase that rent
For
as
months.
per the statute allows, which is once every year or once every 2 years, depending on which lease the tenant chooses to sign. And the law requires that whenever you're sending that lease renewal, so if the lease renewal was due in 2023 and the tenant refused to sign it, then the landlord has to send it out again in 2024 with the same rent that was fixed in 2023. He cannot increase the rent until he gets that tenant to sign the lease renewal. So that's a real challenging aspect of
Mhm.
this for a landlord. And then, the other thing I would like to you to talk about, Mr. Williamson,
Non-primary residence.
what are some of the defenses you've come across in defending tenants in landlord and tenant proceedings?
And we're still in the realm of holdover, correct?
Right. We've already passed holdover. We haven't talked about the defenses. Let's talk about the defenses in both.
Okay. All right. You're going to find a wider range of defenses for non-payment actions if you're the tenant than you would in a holdover proceeding. For instance, if you're going to evict somebody in a holdover proceeding on the basis of rent, especially since COVID, if somebody applied for rental assistance, such as ERAP, and they can prove that they applied for ERAP and that their application was pending, that would serve as a defense to a holdover proceeding, and those proceedings would be stayed until that issue is determined. Also, lack of service of process. That's a common one that you see. Sometimes you can claim that you weren't properly served because, this is a property interest at stake. So if you weren't properly served, you'd likely have a traverse hearing. And if you prevail on that, then that case would be dismissed. By the way, it's important to note that doesn't mean that the landlord would not be able to bring that case again. All right. So now moving over to non-payment. Um, Payment is one of the number one defenses to payment. That's that, okay, look, the landlord, when they start a non-payment petition, they have to first send you a rent demand. New York law requires 14 days. Ms. Washington, if I'm not mistaken, that 14 days was also implemented in the Tenant Protection Act of 2019, right?
I can't verify that at this time. I just know about the changes as it relates to a holdover that happened in 2019.
Right. Okay, because I think it used to be, and I'll check just to, make sure that we have the
No, I
correct
think that's
information.
in the Real Property Act, the 14 days notice requirement.
Okay, because it was a 5-day notice before, but now it's increased for 14-day notice. The landlord is going to let you know what months you owe rent for, pursuant to your lease. So if you can prove that you paid a portion of that rent or all of that rent, then that petition can be dismissed as defective. So payment is top defense. Laches or late fees, they call it. That's a time-sensitive defense in which you're claiming that the landlord could have brought that non-payment action a long time ago, yet they voluntarily chose to wait. That rent goes up, it increases. Now you have an exorbitant amount in the arrears, and it prejudices you with your ability to pay. So you can raise that. Another, and I'll just give one more before I turn it back over to Miss Washington, is that the landlord has caused a de facto multiple dwelling to exist. And I thought about that one because of the first case that I had. If the landlord creates an illegal basement without getting the proper documentation and the proper, licenses to create a space in that basement, then in a multiple dwelling, that is a house with 2 or more rental units. And if that landlord creates an illegal space in the basement or a cellar, then until they get that defect corrected by the Department of Buildings or the housing president, by the Department of Buildings, then they are not able by law to collect rent when they cause the de facto multiple dwelling to exist. And you see that a lot in rent regulated apartments.
Right. The law that you were referencing earlier is New York Real Property Law, Section
12,
711,
111.
711(2), and it requires the 14 days notice. I think it was updated in 2021. That's what I think you were referencing earlier. But anyway, so as it relates to the landlord, because like I said, guys, my strong area is as it relates to the landlord, not the tenant side. And when it comes to the landlord, I would say the landlord has a really not so great deal when it comes to holdovers or rent stabilized or rent control property, because like I said, the only instances you can actually evict on a rent regulated property is either the tenant failed to pay the rent, or you want to evict to take over your property for a family member, or you want to evict the tenant because of some illegal activity,
Mhm.
nuisance, or damage to your property, or a violation of the lease, which is a big one. If you violate any of the terms or the provisions of the lease, that's another situation there. But as I know, a lot of the West Indian landlords, they do not follow the rules strictly. A lot of them don't remember to register the building with the HPD every
Right.
year, every whenever the registration is due. I know it's not due annually, but a lot of them forget to renew the registration. And failure to renew that registration is another grounds on which a tenant could refuse to pay a rent. That's a ground that if you go on a non-payment, you might not be able to get your rent money. And the other problem is with these rent stabilized or rent control, if you don't have a lease, you cannot do a 14 days demand anymore. There's a recent case in 2021 which put a damp on the landlord's ability to do that now. So now the law states that if you do not have a lease, you cannot sue a tenant for non-payment. The only thing you can do is to evict that tenant for failure to sign the lease renewal. If that tenant failed to sign that, you have a right to serve a notice to evict that tenant for failure to sign that lease renewal. And then secondly, to get that tenant out of your property by way of eviction, holdover proceedings, not on failure to pay. It's going to be a holdover proceedings against that tenant. And I think most of the landlords, like I said, the West Indian landlords holding units 5 or more, they don't recognize this. And they don't recognize there's another big problem. A lot of landlords I see from Caribbean country, what they do is that they rent rooms in their property. And renting a room in your house could be detrimental to you if you don't know what you're doing, because then you're going to convert a perfectly good one or two family house into what is called a rent regulated apartment. If you rent five or more rooms in that house and you have, let's say, five or more tenants, then automatically the law says that property will be deemed rent regulated. So now you have a bigger problem on your hand because it's an illegal rent. Well, you didn't get the proper you didn't get it regulated to be under to be considered rooming and boarding, but you're using it for such purposes. And now you have five or more tenants, and now it's fall under the rent regulated tenancy law, and now it's a problem to evict those people from your property. And that is an issue. I've seen it multiple times in court where landlord goes and then the tenant comes with an excuse, and I'm representing the landlord, and then the tenant tells the judge, oh, we have more than five people in there. And I've seen this a lot of times because some of these landlords in one and two family property, they rent the basement. They convert a living room into a bedroom. So now a perfectly good 3-bedroom house is converted into a 4-bedroom, and then they put another 2 bedrooms in the basement. So now it's considered rent regulated. And to evict those tenants, it's a big problem. Because if you fall on hard times and a few of those tenants refuse to pay that rent, you're going to have a problem, because now you can't evict any tenant except for failure to renew their lease, or failure to pay the rent, or one of those other grounds that I mentioned earlier, which is nuisance, damage to property, illegal activity, or a violation of your lease agreement. So, in that situation there, I would encourage landlords to make sure you do things right in New York. New York is not very appealing right now to people who would like to be a landlord. So you just got to be careful, know what you're doing. And, if you're going to have tenants, go by the rules. Get your property, regulated, get the right compliance, get the right certificate of occupancy. Because as you know, if you don't have a proper certificate of occupancy to allow you to rent to a certain number of tenants, that's another defense against the landlord. If a tenant is sued for rent, but you can't use it on a holdover, because on a holdover, the landlord is saying, I just need you out. So whether or not I have a valid certificate of occupancy, it doesn't matter. I just need you out. But in the case where the landlord rent rooms in his property and now it violates the law, the only thing that happens there is the tenant is saying, I don't have to pay him this rent. I don't have to pay him or her this rent because there is no valid certificate of occupancy on the property. So the court would not force that tenant to pay that rent in those circumstances. And like I said, now you have to deal with that 2021 case that prohibits the landlord from doing a non-payment in a case where there's no lease. So landlords, be careful. Mr. Williams, would you like to add anything else regarding the tenant's ability to successfully go up against the landlord?
Well, yes. As far as defenses, I mentioned a couple of defenses for holdovers that would also be applicable to this. If you didn't get served with a predicate rent demand, that predicate rent demand is a jurisdictional prerequisite to maintain a non-payment action in the housing court. So you can raise that as a defense. You can also raise the defense of, the harassment is another one that you see. I mean, it's not often successful, but another claim that I think is going to be one of the most common claims for a landlord tenant is that the landlord is charging above market rent. That's a rent overcharge claim, especially when you're speaking about rent regulated apartments in New York City. Especially, you have two major organizations that regulate New York City apartments. That is the DHCR Department of Housing Community Renewal, and then you have the HPD. Between those, you can file a rent overcharge claim. It takes a couple of years to get through the system, but if you can prove that your landlord is charging you above or is charging you market rent when that building, let's say, should be rent stabilized, and the landlord failed to register, that's a common defense that you see in landlord tenant claims. So the best thing to do is to just contact an attorney, let them know what you know, the claims that you might have, and try to get that done as early as possible. What you see is a lot of tenants going into court, and they'll wait until the case is pushed to trial because they kind of can't come to a resolution with their landlord, and you know, then they'll try to seek an attorney. A lot of people think they have a right to an attorney, but they don't. That's why you want to hop on it quickly. They have legal services that you'd be able to take advantage of, and the best thing to do is to seek legal counsel immediately. These are some of the ways that tenants can arm themselves, and it all starts with going to a seasoned attorney that have done these type of cases often.
Right. Thank you, James Williamson. So, guys, there you have it. Some of the defenses a tenant can use in a landlord and tenant proceeding. And I've given you some valuable information for the landlord. If you're a landlord in the state of New York, within the 5 boroughs, the things that we've discussed today apply to you. So you have to be very careful. And if you're unsure of whether or not you're complying with the law, you can give my office a call. We have people in the office qualified to deal with issues affecting landlords in the state of New York. And especially, I want to speak to the landlords from the West Indian community and make sure that you understand that there are rules and regulations which you must comply with in order to protect yourself. And just remember, an eviction in the state of New York could take you more than a year plus to get through with. So you want to be very careful and make sure you don't make mistakes that could come back to haunt you. Like, I've seen some very crazy mistakes made. Like, there was one lady who wanted to evict the tenant, and I don't think she was educated enough to recognize that the property was still in her father's name, and she was just the administrator for the one of the co-administrator for the estate, and she didn't realize that she couldn't evict the tenants. She had to evict the tenants as administrator for the father's estate. And some of the common errors I see people make is you got to make sure that your name is actually on the deed if you would like to evict. And if it's a multiple family unit, like a three and over unit, and you don't live on the unit, you must ensure that there's an active registration on file for that property. If you fail to ensure, then you're going to be exposing yourself to not being able to move forward with any proceedings against that tenant. You got to make sure there's an active registration on file for any property that you're trying to evict tenants from, whether it's regulated or unregulated. Make sure you comply with the registration requirement for a 3 or more unit that you're not even living on. Okay, guys? So I hope this information that we provided to you today was very helpful. If you need help, and you are listening to this program, or you listen to this program at any time, just give us a call at 718-877-3100. Again, the number you should call is 718-877-3100. If you're in need of legal advice as a landlord, give us a call. If you're in need of advice as a tenant, my colleague James Williamson, we will put you on to him, and he will be able to help you further. But you should give my office a call, which is 718-877-3100, the Washington Law Firm. And guys, also, if you have any other legal issue that you know that we're specialized in, you visit our webpage or Facebook page, and you see some of the areas we're specializing in, and you would like help in those areas, just give the office a call at 718-877-3100. Mr. Williamson, the time is up. Do you have any closing remarks that you would like to give before we go?
Yes, definitely. Always a pleasure to be part of the show. Just like I said, if you ever receive a predicate notice for either a holdover or a non-payment case, Mrs. Washington gave you the number to call. Call that number for landlords, for tenants. She'll get you in contact with me. I look forward to speaking with any of you soon for a consultation. Hope I don't have to, but if I do, you know who to call. Thank you.
Thank you so much, guys. And I do hope that you enjoy the rest of your weekend. And I'll see you back again next Saturday at 4 o'clock. Remember, we're here every single Saturday at 4 p.m. The number to call if you need any legal advice or legal consultation again is 718-877-3100. Thank you, guys.